Yeah, so Los Kaman said that we should look out for the following factors. One, did the Duress have an alternative cause open to him? The person complaining of Duress, when he was threatened, did he have alternative cause, another option? That is not the end of the inquiry. Two, did the party coerce protest? Did that party protest in any way? And three, did the party coerce have independent advice? If you had independent advice, then you cannot complain of what? Duress. Did the party coerce take steps to avoid the contracts? If you took steps to avoid the contract after pressure had been removed and all those things will be very important factors in making a determination as whether duress existed or not. So coming back to the modification contracts, we are talking about like the William and Ruffle brothers and all that. In a sense, you see but let's say William and Ruffle brothers, you have like the main contracts. And it is not the case that the subcontractors had necessarily threatened that they won't do the work. The pace at which the work was going was not satisfactory. And the main contractors were afraid that if they did not provide motivation or incentive for the subcontractors, and they are not able to get their part of the work done, it may affect their ability to deliver on the entire work contract. They went out of their way to promise. And that is why the court said that already they had a contractual obligation to do what? To perform, and then the court said, okay, but if they have not performed, you're going to also get some other displeasure or inconvenience. And for that matter, that can be understood as a benefit and what? And detriment. It looks similar, but not all the time that you'll be able to say that it's exactly a case of duress. If, for example, in that case, the subcontractors had actually made the demand, just as what happened in the DNC builders, that one was quite clear. You're entitled to so much, but take this, otherwise, we're not going to pay anyone anything. So you are put to election and you have no choice. So you just have to give in or live with the threat that they will not pay you at all. Yes, so that is a good observation. So the pressure must be illegitimate. It must be illegitimate. So for example, where there's a threat to breach a contract, there's a contract between A and B, and A has threatened B that unless B gave in to some other things, A was going to breach that existing contract. So that is an illegitimate contract. And it's illegitimate in the sense that it arises from something which is quite unlawful. So the point you made that economic duress is in terms of presentation may come along with the cases of lack of consideration, like the Pinel or even the Duress, what they call the DNC builders, and then the William and Ruffle brothers type of case. But as I said, it will depend upon the person who is issuing the threat. If on your own, you have made a new promise in order to entice the existing, entice the other person you have existing contractual arrangement to do certain things, you cannot later complain that you agreed to the new contract or the modification as a result of duress. But it's different if the person who's supposed to perform the obligation had, for example, made demands that unless you agree to these new terms or this new price, I'm not going to perform, then that one is a different matter. So in some cases, they can go together, but you don't have to conclude that anytime we have a modification of a contract, then there is a case of undue what? Influence. So if we look at the Atlas Express against CAFCO, if you read it, you notice that the agreement was concluded or held to not to be valid for economic duress and also for lack of consideration. But those of us in Ghana, the issue of lack of consideration is not so much a big deal, isn't it? Because of Act. Because of what? Act 25, yes. But certain threats may not appear to be illegitimate, such as a threat not to enter into a contract. If someone has threatened not to enter into a contract with you, well, you don't have an entitlement that someone should enter into contract with you, isn't it? So if the person is threatening not to enter into contract with you, you can't say that that is illegitimate pressure, as it were. Or if someone threatens to sue you, to institute civil proceedings, you are owing me, I serve you a notice, or pay, you are owing me 10,000, pay 8,000, otherwise I will sue you to demand the 10,000 and the interest and the cost of lawyer fees and all that. The threat to sue you is not illegitimate. So that cannot give rise, so assuming you agree to pay, that cannot give rise to what? Duress as a threat. Or someone threatens to call the police. Do this or agree, otherwise I call the police. That is not illegitimate. It is legitimate, isn't it? If you are not doing something which will call for intervention by the police, we look at if someone said that you call the police. Yes, so there's an exception. Okay. Threat of breach of promise to marry, is that what you mean? I don't know if you can explain so that all of us will understand. No, you mean, yes, what is it? And the person and the person agrees to marry you, and later on he will complain that the agreement, the marriage was what, as a result of duress. Oh, of course, when we are doing family law, there's something we call the what we call the annulment of marriage. So if I know you have interest in those matters, but wait until you are doing family law and then you discuss more about that. But for now, let us just concentrate on what we have. Yes. To see what? Your goose. Yes, I think we have provided the answer already. Or what is we provided the answer in this lecture. Will it count as a duress? Unless you agree, I have seized or I'm going to take over your car or your bag. Is that the kind of thing? No, you are talking, there's something called the right of lien, Lien. In that case, we need to find out whether lien is applicable. Lien simply means that you have a legal right to detain or hold on to someone's movable property or something until he or she has met a certain obligation he owes you. So if in law you are entitled to exercise lien, then that will not be illegitimate pressure. So it all depends. No, which one, please? Yes. I'll come and do it. Yes. Yes. Okay, yes, I think that the lien idea is still there because there's an old transaction and you owe him and he's entitled to payment. Something of yours comes into his custody or possession and says that not until you pay me, I'm not going to give it to you. So if you sue him for conversion or debt, as the case may be, you can set up your indebtedness as a defense. So in that case, there's some kind of a right of set-off. Set-off probably cum lien, as the case may be. For the tie to be taken, there shouldn't be. It shouldn't be. You are owing me 100,000. I see a property of yours, and I tell you that if you don't come and pay, I'll take it. And you ignore, I'll take the property. Sue me. While you are doing recovery, you're talking about taking the law into your own hands. So you go to court, there's something we call the preservation order, right? You can go to court and then you let the court make order for preservation so that the person cannot sell it until you have actually gone through the proceedings to determine your claim and all that. Whether we finish or we don't finish, we have to do undue influence. We have to discuss illegality and public policy. Then we need to do discharge of contracts. Then we are done. And all this must happen before the next 2 weeks end. So the choice is yours. So you can use the class platform for some of these questions. Yeah, so I mean, we are just building upon the Los Caman's point. So let's move on. Time is fast spent. Yeah, what are the remedies for recession? You've already stated that, no, remedies for duress. That duress is the contract voidable, not void. And because it's voidable, the automatic remedy is what? Rescission, isn't it? Yeah. But duress is a creature of common law, or is a doctrine developed at common law. Equity has added on to this concept by an add-on concept or related concept called undue influence. And by undue influence, we are saying that a person's free will or judgment was excessively influenced without threat to the person. And usually, it will have to do with relationship. A contract between two parties, because of a certain relationship between them, one of them may be in a dominant position, and the other may be in a relatively weaker position. So much so that the person in the relatively weaker position may not be able to negotiate at arm's length with the dominant party. And for that matter, equity would mean that the weaker party's consent might not have properly been given. And that is the basis for this equitable doctrine of undue influence. Therefore, undue influence is the improper use of power, which deprives a party's ability to exercise a free choice because of domination of another. And as I said, it will usually happen where if you take the two parties to the contract, one is in a superior position or dominant position or domineering position, as it were. Another person is in a relatively weaker position. And for that matter, the contract which has occurred or which has been concluded cannot be said not to have been influenced by the kind of the relationship between them. And if that is so, then there's a need for intervention of the court to ensure that the right thing is done. But we need to appreciate the fundamental distinction between duress and undue influence. With respect to undue influence, there's no use of force or a threat of injury. So there's no use of force or threat of injury. Use of force or threat of injury or threat of use of force, it has to do with what? Duress. But undue influence, there's a stronger personality who dominates the will of the weaker party. Maybe these days, students are even in a stronger position than the teachers. That's what I'm saying. That you like the teacher and the students, employing the clients, doctor and patient, banker and customer, religious leader and a follower, chief justice and what? But let's face it, is there a contrast between the chief justice and other lawyers, the official capacity? I know some of you are being excessively serious, trying to distract the class from what is really pertinent. What is pertinent is for you to know the law of the rest of the people. You know it. Yes. Sorry. You know. Okay, I think. Yeah, please, my mic has gone off, so you have to keep quiet, otherwise you're not here. So, undue influence is based on the misuse of relationship of trust or confidence between the parties. So, clearly, where we have fiduciary relationship or relation based upon trust and confidence, automatically, undue influence is relevant. And where undue influence is established, then the contract is voidable. And at least tonight, everybody is clear in his or her mind what a voidable contract is, as opposed to what? Void contract. So just at the pains of being repetitive, a voidable contract is a contract which is binding or valid for the time being, but may be set aside at the instance or adoption of a party who is aggrieved by any of the vitiating factors, as the case may be. So where you are complaining of influence, of course, you have to apply for rescission. to have the contract set aside. And contracts which are induced by undue influence are of two kinds. And as I've told you, I would like you to supplement our discussion with Mrs. Zona Hammond's chapter 10. So whatever is contained there is still considered important. Then there's a case we call the Hemmans and Coffee, which I will send to you. It's on the 2000, I don't know the Supreme Court. It's very interesting. Of course, those days, apologies to our police officers here, when people used to use police officers to collect debts, right? And then somebody has purchased building materials and he's not paying. You get the police to arrest him. If initially they're looking, they're not getting him. So go even arrest the son. And then later on, you get the father, you arrest him, and then you put pressure on him that if he doesn't have money, he accepts that he owns a house, so he should agree to sell the house so that the money will be used to pay off the creditors. And then the police will facilitate the arrangement of even looking for a buyer and all that. And they get a buyer, the man signs a document, money is made, he pays off the creditor, he's now released from detention and set free. And then he later on goes to get lawyers. Tell lawyers that this has been my bitter experience. And then the lawyers will say that the sale of the property should be set aside. And then they go to court. So you read Hemmans and Kofi. And I'd like you to read the judgment of Justice Aqua, as he then was, but later became the Chief Justice. Very beautiful judgment. Hemmans and Kofi, I'll give it to Hemeans and Kofi. Ezekiel, get me the citation. Hemmans and Kofi. So we have two kinds of situation in which undue influence may be applicable. Contracts where undue influence is presumed. So we have what we call the presumed undue influence and the natural what? Undue influence. So let's look at the two, and then some of the examples that we've given will come under one of them. The presumed undue influence and then the actual undue influence. So the presumed undue influence, we are talking about situation where there's a fiduciary relationship, or one party is in a position of dominance over the other, not the offer over the other. So a parent and a child, parent, of course, can you do a very serious agreement with your parent without the relationship, one way or the other, affecting your judgment, so that if you had probably made a contract with another person, it would have been something else. About 11 to 12 years ago, I did a case involving a father and a son. One of the saddest case I have had to do as a lawyer. The father was, I think, a Pentecost elder. So the son got the opportunity to go to school in the US, some of these things, and the father arranged with his Pentecost friends or network, and then over there, and got a good arrangement for the son. So the son did some kind of industrial work, just a bit of a student work, and was involved in an accident, industrial, accident. And they did an insurance claim, and they had about $600,000, and then ended up giving about $500,000 or $400,000 to the son. Now, the father had gone to Japan to also do survivor strategies. So the son called the father that we'll be at Japan for a long time. This is the way God has opened for me, about $400,000. So please come back home and join mommy. And I'm sending the money down to you so that you can set up something here. And later on, then I also come and join you. So the father abandoned everything he was doing in Japan. And this I'm talking to you is not a story. It's a rare case which went to the High Court. Except that getting to the latter part, things changed. So there was some kind of resolution. So we didn't proceed to prayer judgment. The father came down, he brought the money, he set up some business, and after some time, the son also came down from US. Now, when the son came down, I don't know whether one of the uncles of the son, that is the mother's brother, they had been advising the young man. So the man said that he was at home. One day, the son had gone out and come. Then he came back and told the father that, Daddy, make your will. Make your will. And it was a bit strange, isn't it? The father was not like somebody who was sickly or somebody who was just going to do something like that. And so that was quite strange. And so the father asked him what was happening. In just about 3 or 4 days, the son had gone to Accra to get some very senior officers at the Ghana Police Service. And then they got some of these well-armed young police they used to do various operations. A very special vehicle, equivalent of this peace, the peace goer or something. All the way from Accra to come and take the father, and then intimidate the father to bring all the money the son had got, are giving you. Yeah, it was very pathetic. And he actually got the father detained at the mobile police office, the Patasi. He had some more for about 3 days. All in the name of pressurizing the father to bring the money the son had brought. You see how money can be very dangerous. You have to be very careful. Yeah, so we also have like the trustee. If you're interested, I'll tell you later. If I'm telling you the case, we just, the class will go on. Trustee and beneficiary. You have a trust and then a beneficiary, that is another. And now, when we're doing priority of contact, we explain trust, is it? So you know who a trustee is, don't you? Good. Then solicitor and client is quite obvious. And solicitor and client, again, in 2008, I had the opportunity to get a very huge house. I was doing a case, it was the first case. And eventually I made one of my colleagues to buy that house, one of my colleagues there. I needed it, but if I had purchased it, it would have been like a contract between the solicitor and the client. They were doing divorce, a very huge house, and couple said that, okay, let it be sold so that we share the money. Those days, it was not completed. But those days, it was going for 2008, it was going for now 40,000 and it is 400 gold. But it's a huge house. Now, if you are to sell it, you probably get about 500,000 or 600,000. So, solicitor and client, that is an example. So you have to be worth that. Doctor patient, quite obvious. If you are sick and your doctor said that, okay, I'm doing a treatment for you, become fine. But you see that your house over there, I've always been interested. If you don't mind, I would like to buy it. How much is it going? And said, oh, doc, 1 million Ghana cedis. Oh, can't you do anything about it? Oh, doc, but because you're my doctor, so you can take 500,000. So let's suppose that it was ordinary person who was buying it. I'm sure the person who have insisted 1 million or even more than that, isn't it? Yeah, so that is a kind of thing. Religious advisor and disciple or follower. Your pastor says that, no, he doesn't need to ask what you know. He doesn't need to say that he has seen something about you. It's enough for your pastor to be interested in buying something of yours and you agree, isn't it? And you will not be able to I mean, let's suppose that you have some of these big passes like Duncan Williams or Peter Bale, and they said that, oh, you want to do a transaction with you, let's suppose you're a very faithful member of the church. You're not able to negotiate at the arm's length. But you see, the case of Baffle and Baffle type, it takes care of intention to create legal relation. And that is why it's not necessary here. So you can, if there's if there's a contract between, let's take a merit and merit. Will you say that it's affected by undue influence? Will you say that? Why? Why not? Okay, so that is fine. Okay, we have a few minutes, so let's wind up. Then we also have presumed influence, which we'll be talking about. What are the example? Of course, we'll be talking about the situation of presumed undue influence. So look at the case of the Credit Lyonnais Bank against Batch. Now, presume undue influence, as the word says, presumed, meaning that there's a presumption, there's a suspicion. It's not actual. The difference, actual means that the undue influence has actually crystallized, that the contract was actually affected by undue influence. But the presumed one, there's a rebuttable presumption. There is that suspicion that because of the relationship, the two parties are not likely to have dealt at arm's length. And one's superior position might have weighed on the mind of the weaker party, so that the weaker party might not have been able to negotiate as a will. We are not saying that that's what happened, but that suspicion is what is aroused, and that's why we say the presumed undue influence. Now, how do you demonstrate that the presumption of undue influence should be rebutted? In other words, despite the fact that the contract which took place can come within any of the categories of situation that we have mentioned, and yet it was not affected by the relationship. It was not affected by the undue influence. So to rebut the undue influence, and the burden of proof will be upon the stronger party. It will say like the burden of proof, the one who bears the responsibility to show that there was no undue influence at work will be on the person who is presumed to be the dominant party. So that party would need to do the following to rebut the presumption. One, you need to show that full disclosure of all material fact was made. Now, before the contract was made, all information which will enable the other party to understand what was taking place were made available. Two, that the consideration was adequate. If you look at the consideration provided, it's not different from what usually takes place with respect to that type of contract between other people. So I have not taken advantage of the person. I have not exploited my position to that person's detriment. And then three, the weaker party was in receipt of the independent legal advice. If you can show that the weaker party obtained independent legal advice, so that despite the fact that there was a relationship of undue influence, then you can escape from the effect of that presumption. Yes. That the weaker party was in receipt of the legal advice. Because let's take for example like the banks, right? And it happens all the time. In case of the Barclays Bank and Obrien and so. Somebody is coming to, we are doing a transaction with a customer. and you tell the customer that, please, go and show it to your lawyers and things like that. And if the person gets lawyers to explain it and all that, and if the evidence is there, then that's why the fact that the relationship is one of the presumed influence. You can say that that relationship does not affect the transaction. And if nothing at all, the person was able to get his own independent legal advice before committing himself or herself to the transaction. And then some of your colleagues would like to ask a question. Let's see what they are talking about. Is that I shouldn't move away? Prince Latin. Oh, sorry. Okay, I won't move away again. Okay, because the mic is not there. I understand. Yes. Sorry. Yes, sir. Yes. Okay, no, I'm not even let to land, and let me just answer that what we put over there, they are not exhaustive. In other words, it's not like a close, yes. Yes, you can put husband and wife there. There's nothing wrong. There's what do you call like the presume undue what? But except that, there's a countervailing doctrine which takes care of that. That is why it's not like a big deal. Because already there's a presumption that between husband and wife, there's no intention to create legal relation. In other words, it is not intended that there's a valid contract or binding contract between them. So if there's no binding contract between them, then the question of whether someone freely consented or did not consent is not an issue. And that is why it's not a prominent example. Because the law is saying that between husband and wife, there's no intention to create legal relation. And what that means practically is that the law does not recognize whatever they thought was contract. So if the law does not recognize that, generally speaking, then there'll be no issue as to whether one person did not freely consent or whether the relationship between them actually clouded the judgment of the parties, as it were. So the child and the parent. Yes, so as I said, the same thing, the same analysis will hold good. But all those things that we have said, don't forget the exception. So if they are even listed, they are listed for the purposes of the exception. Husband and wife, we have an exception, like the merit and merit type of thing, where the marriage is not there, no, that isn't it. So even a parent and a child, there could be an exception. It doesn't mean that there can never be intention of legal relations between them. Depending, you see, one thing we should note is that some of these presumptions are just rules of thumb. They are not sacrosanct or they are not iron cast, meaning that it doesn't mean that all the time they are applicable. If you read the authorities in terms of intention to create legal relations, what matters is the intention of the parties. And the intention of the parties, as can be construed from the agreement, as we can infer it from the agreement that they have made, that is what is more determinative, as whether there's an intention to create legal relation or there's no intention. But the case law that we recite are just illustrative of some of the instances in which the court had actually come. But it doesn't mean that they have a magical effect. What is important is for the substance of the transaction itself to be scrutinized, to be examined, for the court to know what you consider the merits of the transaction itself. Can we see that the parties, for example, had intention that should be binding or should not be what? Should not be binding. So you may want to look at the case of Williams against Bailey. A son forged his father's signature on promissory note, And may none of you here ever do that. To forge your father's signature. That is a big sin, isn't it? Now, so there was a case of forgery, and the son did not deny. And the bankers arranged a meeting with the father and issued veiled threats to the effect that if some settlement, some amicable resolution was not made, the son would be prosecuted, because the son had admitted that yes, he did the forgery, that I forged my father's signature. And then the bank was saying, okay, if that is so, then agree to this, otherwise you prosecute your son for forgery. The father thereupon executed an agreement to make an equitable mortgage of his property, and the forged promissory notes were returned to him. So the promissory note which the son had forged were given back to the father, so they could not be used against him. But the bank did not agree until the father had mortgaged his property. And eventually, when the matter came to court, the court held that the agreement was not valid, as in the circumstances, the father could not be said to have entered into it freely and voluntarily, as it were. Now, where there is a special relationship between the parties, then it is up to the defendant or the dominant party to rebut the presumption of undue influence, as we have been discussing. So, see the case of a Lancaster Limited against a Black. Just as the case, the more popular case of Lloyds Bank Limited against Bandy, where an elderly farmer, inexperienced in business matters, mortgaged his home and only answered to the bank to guarantee his son's business overdrafts. The English Court of Appeal eventually set aside the guarantee and the charge thereon, because the farmer had placed himself in the hands of the bank and had looked to the assistant bank manager for advice. That's very similar to Barclays banks and the Obrien meet in the report. Yeah, so as I said, Barclays Bank and Obrien, we actually use this case against this bank. What is the name? We use it successfully to help a woman to escape some of these troubles by some of these banks. If I remember the name of the bank, I will give it to you. And also let to read the judgment, very nice judgment. So Barclays Bank against Obrien. Mr. Obrien was a shareholder in a company and arranged an overdraft with the company's bank on basis that Mr. Obrien will guarantee the company's indebtedness and that it will be secured by a second charge over the matrimonial home, which was currently owned by the husband and wife. And before I move on, if you look at the new legislation on land, the Land Act, there's a requirement that where you are going to use a matrimonial property for loan, there should be what? Written consent. And of course, the banks and those in the financial institution, it is prudent for you to make sure that you don't deal with one married partner without the knowledge, consent, and involvement of the other. Otherwise, when there's a default, the other party will go to court. And as I speak now, we're in court with UMB over some huge debt, almost 40 million Ghana cedis. And they have used, the UMB saying that my client used a number of his properties to secure the debt. And the wife is saying that she doesn't know anything about it. And that is the truth. And the wife has also gone for a lawyer to sue that whatever has gone on between the husband and his company and the using properties that they have jointly acquired since getting married were used unilaterally by the husband without her knowledge, without her consent, without her concurrence. So that is very serious, and that is consistent with the reasoning in Barclays Bank and Obrien. Sorry. Yeah, so though the manager gave instruction that both husband and wife should be made aware of the nature and effect of the documents they were signing and should be advised to take independent advice, the bank staff had not followed those instructions. Sometimes the bank staff, they are in a hurry to do their own thing, just small benefits, or other small benefits, or other they are in desperate quest to meet their targets. Maybe they are giving targets, isn't it? And so they throw caution to the yes. So Mr. Obrien signed the charge document at the bank without reading it. Now, when the company's indebtedness exceeded the agreed overdraft, the bank brought proceedings to enforce that guarantee. Mr. Obrien refused to leave the house, claiming that Mrs. Obrien refused to leave the house, claiming that she has signed the charge document because of her husband's undue influence. So we see the husband and wife thing. And that he had misrepresented the nature of the document so that she thought she was signing a charge up to only £60,000, when in fact the charge was £135,000 pounds. So the English House of Laws, now the Supreme Court, came to the conclusion that the bank must have known that there was a strong possibility that undue influence might have been brought upon Mrs. Obrien to sign, and they should have acquainted her with the full facts in a private interview without the presence of a husband, and should have recommended that she take separate legal advice. And the bank's request for possession of the property was eventually dismissed. So despite the fact that the undue influence involved a third party, the court was prepared to. So Barclays Bank and Obrien teaches important lessons regarding what to be done. Yeah, so of course the situation of actual undue influence. Actual undue influence, as the term tells us, where there has been an actual incidence of what? Undue influence. And that one, you have to establish it by evidence. So in actual undue influence, the reverse burden of proof. It is not there's nothing like a strong or a weaker dominant party. The one who is claiming or the one who is alleging that the contract was vitiated by influence in reality, he or she will have to adduce the requisite burden to persuade the court that the contract could not have been made but for that undue influence, or it was one of the important factors which exercise that person's judgment. So the person alleging the actual undue influence bears the burden of proof. So when he has established that prima facie case, or he has established a case of actual undue influence, then there'll be a reversal of that burden on the other party, the supposed dominant party, who is supposed to have brought undue influence actually to bear on the weaker party. So that is how it works. Whereas in the case of presumed undue influence, the initial burden is on the dominant party. And then when the dominant party has been able to demonstrate that despite the existence of this relationship, it never affected the genuineness of the transaction. Now, I want a sincere declaration. Are you having a class after this? Your response was very weak. Yeah, okay, they say no. Okay, so please, we will have another class. Of course, Mr. Ezekiel will meet you tomorrow, and the discussion will be concluded. Now, next, I think over there on Friday, right? On Friday, in the evening, there'll be a Zoom class. whether you have a class or not, we do it because there'll be recording. If you miss it, you can play the recording. On Saturday or Sunday, certainly Sunday, there'll be another class. So the idea is that by next week, we should finish. And I'm going to send you, please, class reps, I need the groups. I'm going to send you a set of questions. Each group will do one, and they are due for submission before we end. There'll be there is going to be a seminar, a special seminar. And the questions are meant, listen, the questions are meant to be a general revision of all that we've done in the semester. So that is the idea. So we take them serious, all right? Ezekiel, anything? Okay, all right. Yes. Yes. So we are ending because we've ended the classroom one, we have to go off. So have a very good night, and then we're putting the link on the class platform. Okay, thank you. Bye.